Sound is good. Good evening, Linda. So Governor Mike Mbuvi Sonko has now spent 3 nights in custody. He is facing several charges, corruption related with others. And today, long proceedings in court as they seek to be let out on bail. Prosecution opposing the governor's release on bail terms, and they made the case for that. We'll wait to hear what the judge will have to say, magistrate, on this particular matter. But I have with me the Senator Nairobi County, Johnson Sakaja, to talk a little bit more about not the case, because that's before court, but the issues around what this could portend for the county going forward. Thank you for making time for us, Senator.
Thank you.
So many concerns and debate around what this could mean, and a lot of what is being cited is Mumbi Goge's ruling around not accessing office of governors who've been charged. We've seen the same with Waitito as well. Is this a concern for you, and as far as leadership for Nairobi County is concerned?
Well, it definitely is a concern to me, and these are issues I've raised severally. I've raised them with you, I've raised them in the Senate as well. The first thing, without going into the details of the case, obviously, is I think since the day of the arrest and the 3 nights in custody, is that I think there'd have been a better way of handling a governor who is elected by the people. Um, in this case, even after he'd been arrested, we saw him being pushed around. We saw him, a lot of the physical elements of it, I don't think were necessary or right, unless it is people trying to release different pressures. It is not right. I think every accused person deserves a level of dignity, to be treated with dignity, whether they're a big person or a small person. That, for me, from the outset, I think the handling could have been done better.
But Senator, on that point, there are those who would argue it's because he was resisting arrest, it's because he was being troublesome, and that is why it was degenerating to the kind of scenarios we witnessed.
At the initial point where he resisted arrest, maybe that could have happened. But once he was cuffed, even when he came off the plane, we saw him being pushed around, when he was being bundled into the ESCC offices. I don't think that adds anything to it. It doesn't add to the prosecution, doesn't add to the ESCC. I think there's a better way of treating all Kenyans. Secondly, I believe he deserves a fair trial. The issues that are raised are weighty. And really there needs to be a sense of fairness. The right to bail is enshrined in the Constitution. And so unless the prosecution has a very compelling argument against it, I think those are things that need to be taken into account so that we can deal with the issues. The disadvantage or the problem with not dealing with things in a way that seem impartial is that any judgment entered into, or any decision made thereafter, will be seen from the lenses of malice or witch hunt or something like that. So it needs to be treated a bit better. Yes, there is an issue with there not being a deputy governor and the judgment by Justice Mumbi Ngugi. My position has been from before that an elected official must be able to continue serving until they are proven guilty. There is the issue of presumption of innocence. What needs to be prevented is that person interfering with witnesses or interfering with evidence. And if you had the ruling by the Speaker of the Senate through the Deputy Speaker, Kindiki Kithure, it was clear that if the scene of the crime is a problem, the physical premises, then that person should be allowed to operate from a different place, but they still hold office. The Constitution has told us the methods through which a governor loses his seat or vacates his position. Now, in this particular case, if, for instance, they find other charges that then make him unfit to hold office or make his stay untenable, then those other instruments can be applied. And in that case, either for him to appoint a deputy governor, which I've been calling for the last very many months, or number two, for the Speaker to hold office for a limited period pending another election in Nairobi.
Because on one hand, as you talk about what your position is, there is now what they call jurisprudence in terms of this ruling by Justice Mumbi. But on the other hand, what appears to be in conflict with that ruling is what the Deputy Speaker in the Senate said. And so we've seen the likes of Waitito say, yes, I will go set up office elsewhere. But at the end of the day, if in fact that becomes a trajectory on this particular matter, there's no deputy governor, what then happens? For those wondering, does the Speaker then get into office and act for 60 days? What happens after those 60 days? Or is it just the entire leadership coming together to ensure operations don't grind to a halt?
I think this is a predicament that we find ourselves courtesy of the court process. While the ruling of the courts must be respected, it's also our constitutional right, or anybody's constitutional right, not to agree with that particular position of Justice Mumbi Ngugi. I think the courts then should also pronounce themselves in this case on what happens if then there is also the absence of a deputy governor, because her ruling has not been challenged yet. And so since her ruling has not been challenged yet, that remains the prevailing situation, that then if you're charged, you cannot participate in running that office, and you need to step down and leave it to a deputy. The constitution envisages what we call a county executive committee and a county assembly. That's what forms a county government. Within the county executive committee, there are CECs, and the court can even pronounce itself and say that amongst the CECs, one of them be chosen amongst them, or even the court can decree who, but ideally, one of them can come and serve in the position of a deputy governor. That can be done by the courts, but the courts cannot create a problem and then stay silent. Nairobi needs to run, Nairobi needs to work, and when we look at it as an institution, there are certain decisions that can only be made by somebody holding the executive position of governor or deputy governor. And so we need approvals to be done. We need some, dealings with the control of budget, issues with the treasury. Only somebody with that role needs to play it. So if they fail to do that, then a senator will be seeking a constitutional interpretation to actually how then does this city run, because we have leadership and we have interests. A large component of the GDP of this country is in Nairobi. And so the court should not then provide for us a problem or put a roadblock without telling us, okay, then this is the way out in this specific circumstance. That can be done by the current judge looking at this case, or then we shall seek interpretation for the specific case of Nairobi.
And speaking of the importance of Nairobi County, talk to me about whether you support the statement by the Council of Governors asking the president to convene a meeting on this particular matter to be engaged, because some would argue this is a legal process, let it unfold as it should. Should the president be intervening at this point?
What the Constitution does and the County Government Act, it then provides that in such a circumstance where the tenability of a county, there's exceptional circumstances where it cannot be able to run. For instance, if the ruling of Justice Mumingugi is followed, which is the ruling, it's prevailing right now until it is challenged, then the apex body that deals with intergovernmental relations, which is in fact the summit, must then be convened and then a decision reached. And there are two ways to do it. One, any voter can be able to collect 10% of the signatures of registered voters. That comes to around 230,000 in Nairobi. Petition for suspension, and then it goes to the president once verified by IEBC, and the president can then write to the Senate saying that we have moved a motion for the suspension of Nairobi for 60 days, or rather for 90 days, pending an election. And that then becomes an election of MCAs and the governor. Other than that, I think on their own motion, also the summit can say, based on this untenable circumstance or this exceptional circumstance, then we're asking the Senate to pronounce itself and actually allow us to get new leadership, and that then affects the governor. Yeah. So those are the options, and we must deal with the options available, because Nairobi cannot stay for a week, 2 weeks, or 3 weeks without substantive representation. Now, the legislature in the county, and that includes the county speaker, can only act for a limited period. The speaker cannot be governor in perpetuity, because then it goes against separation of powers. In separation of powers, the work of the speaker is to oversee an assembly that then holds the county executive into account. Now, you cannot be presiding over that and this other one for an unlimited period. Even when it comes to the presidential and deputy president level, the Speaker of the National Assembly only can play certain roles for 90 days, and those roles are limited. And that 90-day period can only be extended once by the Senate. Yeah.
Your colleagues in the Senate have been criticized largely on social media. It's a debate ongoing for being in court today. Senator Murkomen, Mutula Kilonzo. And the question is, your role as Senate is to oversight county governments. And here they are representing a governor accused of embezzling public funds. For you, does that conflict stand out?
The first thing I must say is that every Kenyan deserves fair representation of a lawyer, and a lawyer of his choice. Governor Sonko deserves to be represented by a lawyer of his choice. Now, all the lawyers in Kenya are not senators. And so there is a serious conflict of interest when the leader of majority and the majority whip are the ones representing a governor, any governor, whose matter is likely to come to the same house that they're in leadership position. It becomes prejudicial. It means they've taken a position. If tomorrow the governor is summoned to the Public Accounts Committee, will he appear with his lawyers, the leader of majority and the minority whip? And so I think it's a serious conflict. There are many lawyers out there who are not in the Senate. I've said this before, even when it came to the case of Justice Mwilu. I said this when it came to the case of Senator Orengo, I think representing Obado, another governor, because that issue will still come to you. One way or another, actually, one way or another, the matter of Nairobi will come back to the Senate. When it comes to the Senate, you're leading troops. The minority whip whips all the senators from the minority. The majority leader is the leader of all the senators in the majority. You've already pronounced yourself on the merits or the demerits of that particular issue that is coming before you. So it is, I think it is a irreconcilable conflict of interest, and it actually diminishes and demeans the position of the Senate as an objective institution that oversights counties, an objective institution that protects the interests of counties and their governments. Because one individual is not the county, you know. And in fact, it might be in the interest of these people to first sit back, listen to the court, listen to the judgment, listen to the proceedings, and then later, as leaders in this country, pronounce themselves on the matter. Yeah. So you can give support, tacit support. You can give support behind the scenes. As a lawyer, you can give support. You can even help their personal lawyers. But when it comes to the view that in front of everyone, that the leadership of the Senate is supporting inquiries on corruption, yet the Senate is supposed to protect against corruption, then it is a conflict of interest. And I think it is really something that we will raise in the Senate. Yeah.
Yeah, actually, I was going to go to that point, because where do we move from it now being left to people to determine whether it's good or bad, to law forcing them then to act in the way that it does not lose public confidence?
I think there are several provisions that lawyers have taken or swept under the carpet or taken for granted. One, it says state officers cannot be in gainful employment. So if you're running a law firm and you're earning money from accused persons, then you're going against Article 77. Secondly, the obvious conflict of interest, because you're being prejudicial in a case that is coming before you. You're even almost preempting or anticipating debate that will come to the House. The standing orders speak against that. So I think the LSK and all these other institutions need to speak on that. And as I've said, yes, the governor deserves representation, proper representation, and there are many lawyers of competence, of great competence, who can be able to give him that representation. He has his rights. But if you look at it, leave the personalities, look at the institution. The institution of the Senate cannot be the protector of the funds we pass. We passed 15.8 or 9 billion to go to Nairobi. We want to protect those. So you cannot quickly be the same one defending someone being accused. Whether he's done it or not is another case, is another story. But they've been accused and you're defending on a matter that then comes to you, and you'll be asked to give judgment on it. Yeah.
Finally, Senator, do you expect that this may go to impeachment, in impeachment proceedings perhaps to commence in the county assembly?
I think that remains the prerogative of the county assembly. It is for them to decide. I may not foresee it, because really, really, what we've been asking for all this time is a stable Nairobi. Is a Nairobi that we have CECs, we have a county governor, we have a deputy, we have the whole county executive properly constituted, we have a robust county assembly playing the oversight role, not being cheerleaders or anything, but playing the oversight role, and that is what we desire. Right now, I think an impeachment process would throw things off. I don't think it's necessary, but if they choose to do that, they have the right, and if it comes to the Senate, we will deal with it. Yeah. So really, this country is bleeding. We have people in construction who have not gotten approvals for more than 7 months. We have people in the informal sector who are still being harassed, and some people are taking advantage of this lacuna in this gap that is being provided by the case against the governor. In fact, I wish that case would go very fast so that they finish with it. We don't have to have a case that goes for 2 months, 3 months, or a year. Let it go very fast. Let them sit day and night, resolve it. Then we know if he's innocent, he continues his work. If he's guilty, then the court renders its judgment. As simple as that. Yeah.
Thank you very much for making time for the big story this evening, Senator Johnson Sakaja. This is definitely a matter we will wait to see how it unfolds. And remember, in as far as court proceedings and various cases we witnessed in the past, they take quite a long time. And so the scenario that already presents itself in as far as the leadership issues already being witnessed in Nairobi County, and this matter coming in to complicate an already difficult situation for the residents. But many will hope that at the end of the day, in terms of service delivery for residents of Nairobi County, that will not be hampered by the same. Hey,